why they're often called secret hearings, is sometimes you can't even find out they exist. They're that, secret and closed to the public.
I'm Justin Silverman of the New England First Amendment Coalition. Many thanks to everyone who supported NEFAC in 2021. We're incredibly grateful for all your help defending the First Amendment and open government in New England. We have many exciting programs and services being prepared for 2022, and it's all because of you. So, on behalf of myself and everyone at NEFAC, thank you for all you do, and have a productive and healthy new year. I'm here today with Anastasia Lennon, the reporter at the New Bedford Light. Anastasia, thanks for joining us.
Thanks for having me, Justin.
Anastasia, you recently reported on a concerning situation where a local court is banning the public from attending a hearing in a high-profile criminal case. Can you catch us up to speed? Tell us what this case is all about and what led up to this hearing.
Sure. So in early November, Keith Hovind, he's the longtime president and CEO of South Coast Health, was arrested by Rochester police for assault and battery, a charge that's since been dismissed in district court because the victim chose not to testify. But there's still a possible charge remaining, as is typical police procedure in an assault and battery. Police will remove any weapons from the home. And so in the case of Hovind, he had multiple firearms, thousands of rounds of ammunition, and firearm magazines, or they call them feeding devices, that were all securely stored in his home. But Rochester police allege that some of these feeding devices or magazines are illegal. So they filed an application for a felony charge for possessing these illegal magazines. And so what happens in that process next is what's called a show cause hearing, also called a clerk magistrate hearing, which will basically determine whether Keith Hovind will be charged with this felony.
So tell us a little bit more about these show cause hearings. Are these typical proceedings common in every state? Are they unique to Massachusetts? What are they all about?
So I'll start just by explaining what they are. So typically they happen when someone hasn't been arrested, but law enforcement wants to charge you with something, or just so anyone can really file an application for a criminal complaint. Often they're just misdemeanors. They can also be felonies. But what happens then is there's this hearing where a clerk magistrate, they're called, they're not a judge necessarily, will hear the case and determine based on probable cause whether there's enough evidence to charge this person with this crime. And so I'll have to attribute this next piece to some really wonderful Boston Globe reporting with the Spotlight team, but they found that Massachusetts is the only state that really has these closed door, or as they call it, secret hearings to determine if people are going to be charged with a crime.
And why were these types of hearings created? Why is the state holding them in secret when we have a First Amendment right to open courts?
Yeah, so I don't know too much of the history of how it developed here in the state, but I do understand some of the reasoning. It's to try and protect the privacy rights of individuals. Someone could come into the courtroom with baseless claims, and if the magistrate doesn't find that there's probable cause, the person's not charged, then the idea is, well, you don't want the public to know this happened. They were never criminally charged, but if it is public, anyone can learn about this. It could lead to embarrassment, notoriety they might not want. It can hurt their reputation. So that's some of the reasoning as why the privacy of the individual is sort of put first here, instead of like the First Amendment right where we could have access to this hearing.
So under what circumstances, if any, are these hearings open to the public?
Yeah, so my first encounter with these show cause hearings, I was successful. It was while I was a reporter at the Standard Times, and it was there was a show cause hearing for a city councilor, Hugh Dunn, possible OUI charge leaving the scene of an accident. And so with the help of attorney Peter Caruso, who's with NEFAC, we submitted a motion to the Fall River District Court to open this hearing, and it was successful. So I was able to sit in this hearing, as was any member of the public if they wanted to. where you had the city councilor, his attorney, and then the prosecutor calling witnesses and really seeing this all play out. And if we didn't petition for access, or no one did, no one would have been able to sit in that courtroom or see what happened. And in the case of the city councilor, Hugh Dunn, the magistrate did find probable cause, so the city councilor was charged with OUI and leaving the scene. And so that's what we're trying to do here with the case of Hoban, is sit in that hearing room and hear what transpires.
Anastasia, going back to this previous case, the one that you covered while you were at the Standard Times, can you explain to us some of the arguments that you made that convinced the court to open up the hearing to public scrutiny?
Yeah, so I based a lot of it on this document, which is available online. It's with the State District Court Department, and I recommend any reporter read it. It was pretty interesting, I think. But you can you make two arguments. It's not enough to argue that they're a public figure or well-known. You also need to argue that the case has already been well publicized, which in turn sort of diminishes that interest in privacy because the public already knows about it. They know the details, the allegations. And in Hoban's case, New Bedford Light isn't the only outlet that's covered it. There have been several outlets that published several stories, not only on his arrest, but what has followed since, including Rochester police seeking this felony charge. So that's what we're arguing here. Keith Hoban, he leads a healthcare organization with thousands of employees, but people know the details of this case now, and so we're just arguing that the public is aware and would like to know, how this will resolve or how it will be adjudicated, and if he's not charged, they'll want to know why he wasn't charged.
So I know there have been some legislative attempts in the past to do away with this secrecy, to change the whole structure of these hearings, but that hasn't happened yet. So can you explain for those that are unfamiliar with the court system, that don't work in newsrooms, what's at stake if this secrecy continues? What do we risk losing as members of the public if we don't have access to these hearings?
Well, I guess in simple terms, it's hard to hold elected officials, institutions, systems accountable if you don't know what's going on with them, if you can't see behind the doors or on the other side, and so it's a means of ensuring accountability and transparency in the process. I want to refer to that Globe Spotlight series again, because they really dug into these hearings and found that elected officials, police officers, they're not getting charged even if there's evidence that they did commit a crime, and that's what does happen sometimes in these magistrate hearings, is that even if the magistrate finds probable cause, they don't always approve the application, meaning the person won't be charged even if there was evidence they did the crime. So there's also a concern there in that process of maybe people getting away with things, and not to say that is the case necessarily here, just in general with this system. So it really comes down to just ensuring transparency and accountability.
Anastasia, as we wrap up here, I think it's important to note that not only are these hearings held behind closed doors, usually the public isn't even aware that they're occurring. There's no public posting that these hearings are even happening. So how did you find out that this hearing was going to occur?
So I did confirm with the district court clerks. I mean, whenever I call the clerk's office, there any number of people answer the phone. So a few times I did confirm with them. I will say I did call yesterday again to confirm the date as it approaches. And in that case, the person wouldn't answer me, and they said, that's not public information. So they declined to comment on that. And, that is an important point though you raised, is that that's why they're often called secret hearings, is sometimes you can't even find out they exist. They're that, secret and closed to the public.
So what are the next steps here? I know you and your colleagues filed an appeal to gain access to this court hearing. What's the status of that appeal? And if that appeal doesn't go your way in the way of public access, what are the next steps?
Yeah, so I guess just to take a step back, so we filed the motion to access with the clerk magistrate. He denied it, and he cited privacy reasons. He said that This hearing has no connection to Hogan's position as CEO, nor his charge again that was dismissed with assault and battery. And he called the issue, quote, a separate personal matter, and that Hogan's privacy sort of outweighs the public interest. So that was the reasons that he cited. I appealed with the district court judge, and I asked that he get back to me by the end of today, because today's the 6th and the hearing is scheduled for the 10th on a Monday, so we don't have too much time. And if the judge also declines that, then our plan would be to go to the state Supreme Judicial Court and try to appeal it with them.
Well, let's hope that you get a favorable ruling and you're able to get access to the court and continue reporting this very important story. Anastasia, thanks for all that you do and appreciate you being here with us today.
Thanks so much for taking the time to talk.